Hi, and welcome to FloridaDivorce.com. Today I'd like to talk to you about the basics of an uncontested Florida divorce. An uncontested Florida divorce means that all issues pertaining to your matter are agreed to and that there is nothing left for the judge to decide. Those issues may include alimony, child support, visitation, now known as timesharing, division of property, division of debt, and who is going to pay attorney's fees. It's certainly less expensive, less time-consuming, and less aggravating to come to an agreement on all issues than it is to have a contested divorce where the judge must decide the issues. And note that it's possible to agree on some issues with your spouse and have the judge decide the rest. Make sure that your lawyer is experienced and that you're comfortable with him or her. Your lawyer may have a lot of experience, but if you're not comfortable working with them, there can be problems. And don't hesitate to ask your lawyer if they have a significant amount of experience with your particular type of case. Of course, you need to make sure that the pricing is competitive and not too high or too low. Too low a price may indicate that the lawyer is not busy or experienced, and too high a price may suggest that they are overqualified for your type of matter. And you don't necessarily need a superstar attorney if your matter is uncomplicated and you have agreed upon everything. The lawyer should be willing to answer all of your questions and make sure that you're getting a fair deal. The lawyer should further advise you of what your rights and responsibilities are. Unless there are absolutely no financial issues that need to be addressed, each party will fill out a financial affidavit which will list income, monthly expenses, assets, and liabilities. If children are involved, a child support worksheet will be used to calculate child support pursuant to the Florida Child Support Formula. And each party will be required to attend a Children in Divorce seminar, which is online. Further, a Uniform Child Custody Jurisdiction Act statement must be filed with the court when children are involved. That affidavit indicates as to each child where they have lived and who they have lived with in the last number of years. More importantly, a parenting plan must be filed with the court that the parties sign after agreeing upon a time-sharing schedule and other matters related to the minor children. It's a lengthy document which will define not only time-sharing, but other matters pertaining to the children, such as other interactions with each parent. The document will pertain to property, child-related issues, and the like. Additionally, the attorney may prepare an income withholding order so that child support will be taken out of the paycheck of the paying party. Once both parties execute the agreement and all of the court-required documents, a hearing will be scheduled before the judge. The judge will hold a very brief hearing to make sure everything is in order, and in particular, to make sure that the parenting plan and settlement agreement provide what is in the best interest of the minor children. If everything is in order, the court will sign a final judgment of dissolution of marriage, which will be the formal document resulting in the divorce of the parties. This will approve and incorporate the settlement agreement and parenting plan. The judgment is effective immediately, and it should be noted that no court appearance is necessary if Attorney Gruskin represents a party on a Florida uncontested dissolution of marriage. In that case, the final judgment can be rendered approximately 30 days after the filing of all court-required documents with the clerk of the court.